Someone make it make sense.
Probably a couple.
Hello, squirrel friends. Happy to see you guys. Shout out to IS. Shout out to Tennis Girl 101. And let me put some commands in the chat here. IS, if you would like your own custom command, please let me know. And we will get that set up for you. Rather, Nightbot will, because he's just the best. He has little hands, but a big heart. And let's see, he might be napping a little bit. It takes a lot of energy being so cute. You know what I mean? So let's see if he's gonna wake up here in a second. So really excited to be back with another live stream here covering Idaho, BK. Oh, there he is. Okay, cute. We love you, Nightbot. Yeah, so we've got a lot in store here. I've put together a lot of things to help us go through the timeline. And I'm really excited. I think it's going to make it a lot more clear for you guys what dates we do have, what dates we don't have, what and you know, and what is missing. And I think it's going to help to have those visuals. So we're going to go through that too. That's something that I was kind of working on, especially when I had laryngitis because I couldn't live stream. But we're going to start out first with the last of the most recent documents, apart from the documents that are just like things are sealed, right? By the way, speaking of which, the witness list for the upcoming hearings on the 23rd and the 24th has still not posted. As per the scheduling order, the defense witness list was due by the 9th. And, you know, in the event that they may be asked for more time, there's not been a filing of them asking for more time. So I imagine it just hasn't been posted on the docket yet. I mean, additionally, too, if it was going to be if they were going to submit it, but it was going to be under seal, we would see that filing as well. So there's not been any filing at all regarding that witness list after the scheduling order. So, but I refresh that docket like many times a day. And as soon as we have that, I will definitely go live with that. But this is the last filing in the slew of filings that we were covering from the last one. So we will start with this. And also shout out to, I can't remember, did you say it was thank you knots or tie knots? I know I asked you this and I can't remember. I'm sorry. But you're very welcome for this live. Glad you're here. Glad to see you. And for anyone who is new here too, we would love to have you as a part of the Squirrel crew. Feel free to join the Discord as well. And Nightbot will put a link for that in the chat. And that way you can chat with all the other squirrel friends and stay up to date with everything. Tie knots. Thank you. It's hard to not see it and think thank you. So I appreciate you saying tie knots. And I guess, you know, your thumbnail should have made that more obvious to me now that I look at it, right? Are you like an expert knot tire? Because if so, that's pretty cool. But what I was going to say is for anyone who's new here, a couple things I wanted to mention, which is, first of all, in any case, right, it's always what we can always strive for, right, as those who follow cases, follow trials, we can always strive to be the best versions of ourselves by, if we can, I know sometimes it's hard, but if we can wait before deciding if we think a suspect is, you know, guilty or not guilty, or would a jury find them guilty or not guilty, or what do we think, whatever, any of that, until trial. And I will just say this much, that if ever there's a case where that is maybe the most applicable, I would say potentially, at least in recent memory, that's this case. And why? Because the gag order being put in place almost immediately, we have like next to no information. And again, what we're going to look at, those video presentations that I put together, is going to hammer that home, that even when we do get information, you know, of course, the information has to come from the state, right? That's where the discovery comes from. That even when we do get information, it's missing so much. And that's besides what's under seal, which is so much. So, you know, so that I was going to say first. The second thing I wanted to reiterate, because I know that there's been some people that have posted comments, which I welcome and I appreciate, posted comments about things like both sides playing games, stuff like that. And I just wanted to reiterate that in any criminal trial, okay, it is the job of the prosecution of the state to supply the discovery and to turn over the discovery. They have the obligation to do that. So to the extent, if in any case, this one or any case, right, if the defense is quote unquote playing games or whatever, that really is different than when it comes from the government, because they have the duty. They have a lot of duties, right? And especially when it pertains to discovery, because again, all the discovery comes from the state. And funny enough, I was running errands today, and I caught just like the tail end of EDB's live stream, and and I was listening to it in my car, Bluetooth, and it was like during her Q&A section. And it's funny because she hasn't mentioned, Bryan Kohberger or Idaho in a while. At least I haven't heard it. It's not really come up, and she's not covered anything recently with that. And she didn't today either. But in the Q&A, so today she was talking about Baldwin, okay, and Carrie Morrissey and all that, okay. And during the Q&A, she was answering a question or whatever, and it was really funny because just the coincidence that, just as an aside, she actually referenced this case because she was talking about how prosecutors have a duty to turn things over and to not hide the ball and to not be shady with this, right? And to not play games. I think she actually even said to not play games. She said that it's different when it comes from the prosecution because they need to be forthcoming and play by the rules. They're the ones that brought the charges. And she actually said something like, unlike what's happening in Idaho. So in other words, that to me means she's been reading these documents, but she's not covered them. At least, I'm sure I would have seen it if she did. But I just thought that was interesting because, for anyone who thinks that I'm just saying things or that I'm biased, I really try hard to present things very, very fairly and very evenly. But I think that for anyone, including someone like Emily D. Baker, right, who is the former DA out of Los Angeles, y'all, I'm sure are already familiar. But if you've read all these court filings and you've watched all the hearings, even if you're not biased, right, it's hard to say that the prosecution is actually turning everything over as they should, that they're not playing games again. And it came right from EDB's mouth today, just coincidentally. But it's clear. And again, when we get to the videos I put together for you guys, I think y'all will see that this is pretty unusual. Even in freaking Karen Reed, right? And as we gear up to the second trial with the new special prosecutor, even in that case, right? Hank Brennan has said, and to my knowledge, has done what he said, right? He's made good on this promise that he's turning literally everything over, even if it's just stuff that he doesn't know what it is, or it may not be relevant. He's turning it over, right? So anyway, I just wanted to mention that I really, I don't come into cases with a bias. I know every human has implicit bias, and that's a human thing, and what have you. I get that, but I try to present everything very fairly. But again, I think that anyone who takes an objective look and has covered read all these filings and watched all these hearings, I don't know how you could come to any other conclusion other than the state here is not doing their best job that they could to turn things over, and to be transparent, even if it's under seal, right? There's just a lot of issues. So I just wanted to point that out. Shout out to American Princess. Glad you're here. You're very welcome for that update. She did say she will be covering the hearings. I did hear her say that as well. And I also plan to cover those hearings, of course, right? Ever since I started, I cover literally everything. I don't know that I'll cover them live as they happen. I might cover them after the fact. I'm still sort of waiting to see what's going on, because it used to be the type of thing where when they were streaming live, the BK hearings, if you were watching it live and then you paused it or whatever, once the actual feed ended, you couldn't catch the rest of the feed. I don't think that's still the case, but once that became the case, just to be safe, I was covering them after the fact, so that, you know, you don't end up in that situation. But anyway, but yes, you're very welcome for that update. So, okay, so we're going to start out here, like I said, where this is from, what was this? January 7th. Okay. So this is the reply to the state's objection to the defendant's motion to compel ICR 16b7 material and for sanctions. And this was as pertaining to their expert witnesses. Now, when the previous live stream, we talked about this. This was crazy to me. That, I mean, again, talk about like, you can take a completely objective stance to this, right? But when you hear that of the 25 expert witnesses, right, that the state has listed, that while they submitted CVs for all of them, great, fine. Only 5 of the 25 did they submit any type of report for. And for the other, and for all 25, they did not submit their final opinions. And then for the other 20, no report or opinions, just CVs. I mean, there's no other way to look at that, right? That's, you know, and I want to give another example real quick. I'm glad I thought of this, because when it comes to playing games, right, quote unquote, a good example is like in the Casey Anthony trial, which I've been covering gavel to gavel, and we're in the defense's case in chief, and they've had a lot of expert witnesses and they have more to come. The state, okay, during their case in chief had been playing games, right? Or as Judge Belvin puts it, they've been exercising in gamesmanship, right? They were playing games with their expert witnesses where they were going to present a new opinion. And in one case, they didn't provide the photographs to the defense and all that type of stuff, right? And so as a result, that shit couldn't come in, right? Now, in the defense's case in chief, now they're having other issues with the defense expert witnesses where similar things, right? Where there was a new opinion or they didn't get something turned over, similarly to what the state had been doing, right? And because of that, the state requested sanctions, and Judge Belvin is still mulling that over, but it looks like there's at least going to be a jury instruction or whatever dealing with it. So my point was this, okay? Because again, the standard and the bar has to be higher and is higher for the state, because they are, especially when it comes to discovery, right? Turning things over. But my point was this, that if either side, okay, is quote unquote playing games, and the games that they're quote unquote playing are actually hampering the judicial process and are actually not allowed, or they're violating a court order. And in the Casey Anthony trial, in that case, with the defense, it was a specific court order specific to that trial that Judge Belvin had ordered that they apparently had violated. Okay. So if that does happen, okay, they get punished for it. They get sanctioned for it. So in other words, you know, for anyone saying that in this case, for example, like that either side is playing games, right? Or especially the defense is playing games, because a lot of people tend to say that. Playing games is fine until you've gone past that, right? Like, in other words, there's a certain level of strategy that goes into a trial. Now that, again, when it comes to discovery, that should not be part of it. Discovery, you turn it over, that's it, right? But the defense, right, as they're just the recipients of it, right? If they were doing anything that was actually not allowed, was actually violating any type of law or court order, like we saw in Casey Anthony's case, then they would get sanctioned, right? So to the extent that that's not happening, which it hasn't yet, right? They're not doing anything wrong. Now here, again, the first sanctions asked for in this case are for the state. And you might say, well, this is just the defense. I mean, I can't tell you guys how many videos I saw on YouTube where I just saw the title pop up, right? And I can't even tell you how many of them said, these people did not, and I'm talking, it's mostly like mainstream media, right? They did not read this. They didn't read any of these filings. They didn't. They must have read just simply the title from the docket and saw something about expert witnesses or whatever and assumed what it was. And so the things that I was seeing were things like The defense has a problem with the state's expert witnesses, or they're trying to not incorrect, completely misinformation, right? Everybody that watches trials knows that when you are the state, either side, right? Well, okay, the burden is different for the defense in a criminal case in terms of how they have to also submit their final report, right? Because that's expensive. But for the state, okay, they have to submit the CV, they have to submit the report and any data relied upon, and they have to submit their final expert opinions. They have to. It's in the Idaho criminal rules. It's in the federal rules of evidence. It's not optional. So the fact that the state didn't do that, this is not just the defense playing games. I mean, again, do you guys see what I'm saying? Like, there's no other way to look at this. It's insane to me. And that's why they're asking for sanctions. And because of the fact that, as we covered on the last live stream, the defense is alleging that this was intentional. And I mean, common sense would tell you it had to be, because how the fuck else would you not submit expert reports and opinions? It's like there's no reason you wouldn't submit that. It just defies logic. Like, why are you not submitting it? And then to try to weasel around it and say that these are all going to be rebuttal witnesses. You're going to have 25 experts in rebuttal and none for your case in chief. I mean, it's just, okay. So anyway, shout out to Black Witter. Happy you're here. Shout out to Candace. And yes, and anyone else who's joining us, glad you guys are here. Happy to see y'all. Okay. So hopefully that kind of gets everybody kind of up to speed, but you guys are probably already aware, hopefully, and have maybe watched the last live stream. So yes. Okay. So the motion to compel ICR material, that simply is what they should have already provided, which is what are the experts' final opinions? What's their report? I mean, to only submit a CV, I don't even know who you think you are to do that, to be honest. Like, this is insane. Okay. So we already had covered previously the initial motion and then the state's objection. So this is the reply to the state's objection. Okay. So Mr. Kohberger asserts the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. Yep. Idaho criminal rules and the U.S. Constitution. Mr. Kohberger cannot fairly confront the evidence the state intends to bring against him when he does not know what it is. And remember, the other thing looming is that on January 23rd, the defense had a deadline for them to submit their expert witnesses, I believe, for the sentencing phase, maybe. No, sorry, for the guilt phase. And they can't decide what witnesses they need until they know what the opinions are. I mean, this is insane. So again, the motion for sanctions, right, being that, how are they supposed, and the state knows this. So naturally, the defense also had made a motion to extend their deadline because they can't do what they are supposed to do by the deadline when the state just completely failed to do. I mean, this is insane to me, of all the things. His counsel cannot be adequately prepared to represent him at trial given the state's lack of adequate expert disclosures. Again, this is basic, guys. Failure to properly disclose expert opinions by merely disclosing a list of topics an expert may testify about or leaving open-ended opinions, in essence, shifts the burden to Mr. Kohberger. And again, just to reiterate, they've not objected to any of these experts. They're not saying that they don't want, they're just saying we don't have their opinions, we don't have their reports, and that is what the law requires. He is forced to respond to unknown expert opinions with unspecified scientific, technical, or specialized knowledge while giving the state the ability to disclose its further or actual expert opinions in rebuttal filing on February 13th. So what the state basically had said, and again, we did cover this previously, was they wanted to wait and get the defense's list of experts before then they submit their list. That's backwards. Like, are you like, okay. This failure to disclose expert opinions not only prevents Mr. Kohberger from confronting evidence against him, but also prevents him from assessing his need to file motions limine and motions to exclude expert witnesses who do not meet Idaho's evidentiary standard. So, like, in other words, like we see all the time, right? Like if they do make a motion to exclude certain witnesses, they haven't done that yet because they can't, right? But if they do, there could be, oh, keep reading. I was going to say a Daubert hearing, right? Otherwise known as the Daubert-Frye hearing. Yep. Deadlines are looming. Yep. This motion cannot be heard until January 23rd, and that's the actual defense deadline, as I just said. Motions in limine are due February 10th, 2025. A motion to extend time to file some is filed. The motion to, so we already covered that again. I already mentioned that. The motion to extend time, we already filed that, or covered that. Okay. The court has the state's sealed exhibits S1 through S25. The state's filing consists of over 400 pages, mostly curriculum vitae, fucking hell, of the named witnesses and very few details of expert opinions with a few exceptions. Approximately 2,000 pages of discovery are referenced in the DNA disclosures. The court does not have the discovery pages in the expert disclosures, but for one example, attached to the state's objection as S1. Most of the disclosures have catch-all phrases, that the expert will rely on the work of unnamed others, that the disclosure is meant to be an aid, but does not encompass all finding, impression, conclusions, or materials related to this experts involved in this case, or that the disclosure does not in any, I guess, way limit the scope of the expert's testimony. Okay, first things first. When we get, again, to the videos that I put together for you guys, you're going to see why this is really interesting, right? Because this is par for the course. The experts relying on the work of unnamed others. Just wait. Keep that in your minds when we go to the videos, because one of the videos is called Who Did What When, okay? It's as if there's a bunch of ghosts working for the state or something like that. It's crazy. And then the second point here, right? That the disclosure is meant to be an aid, but does not encompass all finding, like literally this. Any of you guys that watched Sarah Boone, right? You guys remember the Richardson hearing in the middle of trial? And this has come up in other cases, but that's just a recent example, right? They can't offer a new opinion. And literally, like, this blows my mind that they, A, didn't put an opinion at all, and then B, said basically that they're relying on the work of unnamed others, and then C said, this isn't going to encompass everything. They could come up with other stuff. You can't, I just don't even have, I don't have words. The whole point is this is everything they're going to testify to. I can't. This language essentially places no limits on the testimony of the expert and places Mr. Kohberger at a disadvantage. I mean, this is an understatement, in my opinion, because he cannot prepare for an unknown opinion of an expert that would be proffered for the first time on the witness stand in front of a jury. It's insane. Hi, DSN. Happy to see you. DSN, he's got a bird in his mouth. Y'all know the drill. We do have the sound bits for this. Give me a second here.
Hey, he's got a bird in his mouth. It's a guinea.
This is a chicken.
Awesome. Yeah, I'm glad also too. And we're going to get more into the DNA with this as well here. So, okay. These disclosures do not allow Mr. Kohberger to evaluate the scope of the opinion, assess how his own expert witness will need to respond with countering opinions. And that's the whole point, right? The state goes first, and then the defense responds. Prepared to confront the evidence the state intends to elicit, allow counsel to competently prepare for trial, and determine if a motion to eliminate or motion to exclude will be needed. It's just. So then they attach the exhibit B under seal. Okay. The state's objection to the defendant's motion to compel acknowledges its duty under the rules, the quantity of 68 terabytes of discovery, and the disarray to which the state has both received and produced the discovery. The state interprets the motion to compel as one of complaint that adequate information has not been provided. The other thing that the state, and the state's, yeah, so in the state's objection, they didn't address any of the actual issues. They didn't address any of them. The first, and you guys, if you watched the last live stream, you all saw me lose my mind because the first thing they start with was that they turned everything over in a timely fashion. No one, the defense included, ever, it was, their motion had nothing to do with the timing of it. It's just, they started out by counting the number of days until trial. Oh my God. Like they completely ignored the issues raised by the defense and instead said things that they did that were not the actual issues. Anyway, so like, for example, the amount of discovery, right? The 68 terabytes of discovery. And again, the date that they turned over the expert witness report, not reports, but the list, I guess, that's not the problem. The problem is that the expert witness list is missing everything that is supposed to be there. Anyway, Mr. Kohberger's argument is that given the overwhelming amount of discovery in this capital murder case, compliance with discovery rules related to expert opinions is vital to be informed of expert opinions being offered against him. Mr. Kohberger's expertise note, I mean, again, this just goes without saying. It's obvious, right? And beyond this, the state has violated the rules. Like, that's the main thing to me, right? Let me see what this footnote is. Right. Okay. A single terabyte is equivalent of 75 million pages of text. So 68 terabytes would be 68 times 75 million. Excellent. The discovery rules are designed to safeguard the truth-seeking functions of trials, promote fairness, and or to facilitate fair and expedited pretrial fact-gathering and to prevent surprise at trial. The expert witnesses the state discloses are all relying on underlying data and technical or specialized knowledge, but what they intend to testify about using such knowledge is unknown. Footnote 2. The state submitted S1 to its objection as an example of discovery that qualifies as an expert report. This exhibit is a list of items collected. If the witness associated with this list is simply a chain of custody witness, an opinion is not necessary. If the witness will testify that evidence was collected in accordance with their training, proper procedure, and lab protocols, that calls for and qualifies as an opinion. The lab protocols, blah, 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 blah. Okay, if state wishes to elicit her opinion regarding whether or not evidence was collected in accordance with their training and lab protocols, that is an opinion. If the state wishes to elicit any results of the test and what they mean, that is an opinion. This is a good example of how the state's disclosure related to DNA are lacking in this case. So where was, hold on. There was, right, this was the part I was looking at. Yeah, right here, the DNA. 2,000 pages of discovery are referenced in the DNA disclosures. The court does not have the discovery pages, except for one example. And again, remember, like I said, guys, keep in your minds, right? The part relying on the work of unnamed others. Okay. Now, hi, Jilly Fruit. I'm so glad you're here. Is this the first time you've been here for one of the live streams? I'm so happy to see you, though. Awesome. Hey, be thinking if you want a custom command, you can see a lot of examples of those in the chat. It would be like !Julie, and we will get that set up for you. So now, here's where we're going to get, it gets more interesting. So now we're going to go to this. We're going to revisit. So this is from July 2023. So this is the state's reply. So when they made the motion for the protective order, then we had the objection, and we've covered all that at length. This is the state's reply. And this is going to be really relevant to the videos that I have put together for you guys, okay? Okay, so this is in there. So the defendant has not demonstrated that any subsection of Rule 16 requires the disclosure of IgG information. It follows that the state need not disclose information that does not fall into one of the discrete categories, at least absent an order from the court upon motion from the defendant showing substantial need in the preparation of the defendant's case, and the defendant is unable to, without undue hardship, to obtain the substantial equivalent by other means. First, defendant baldly asserts that the IgG information rather obviously falls within the ambit of Rule 16b4, but fails to explain how that conclusion results from the language of the rule. So this is the rule here, okay? I was going to pull it up, but they already have it here. So the documents or tangible objects have to be A, material to the preparation of the defense, B, intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belong to the defendant. So we know that as it pertains to the IgG, B and C don't apply here, but A certainly would, right? As best the state can tell, defendant is not asserting, right, that B or C applied to the IgG information. Presumably then, the defendant was attempting to show how the IgG information is material to the preparation of his defense, when he asserted that someone other than the defendant may have placed his DNA on the K-bar knife sheath. Now, I don't know that that's okay. People have taken the whole, there's that one line from the defense filing that says, that just references the knife sheath, and they say the knife sheath, they use the word placed there, right? Placed, whatever. But when everyone freaked out about that and thought they were implying that he was framed, that's not how I interpreted it. I think that that to me reads as standard languaging for a defense filing, because you don't, otherwise you're almost admitting that the defendant left it there, right? I mean, that is just standard languaging in my view, that, you know, and not only that, but placed there, it could have been placed there by him, right? It's just like that. How did it get there? It was placed there by somebody, right? Anyway, but it looks like the state wants to take that idea and kind of run with it here, but that's not the issue, in my opinion. But the state is at a loss as to how that theory supports the claim that the IgG information is material to the preparation of his defense. Okay, get ready, guys. The SNP profile used in the IgG was created from the same DNA used for the STR analyses, and the state is providing the SNP profile and information related to the STR analysis and discovery. A defendant wishes to explore the theory that the DNA, I don't know that that's what they're doing, but whatever, he is free to do so. But the family tree created by the FBI has no relevance to that theory. But we're going to get to this, guys. You just wait, just wait. Next, defendant attacks an argument the state never made. He claims the state argues that if later STR testing is accurate, then there's no reason to concern ourselves with how the state came to investigate Mr. Kohberger. But for purposes of this motion, the accuracy, and I have to say, right, this is why one of the things we're going to look at too is the timeline of the white Elantra versus the DNA, because that's the question, right, that the defense has been asking, and we still don't have an answer, right? Like, when and how did they first get to him with the name, right? Like, what was the, and we're going to look at it, don't worry. But for purposes of this motion, the accuracy of the STR testing is beside the point. The state referenced the STR testing in its motion to demonstrate the difference between STR analysis and the SNP profile used to conduct IgG. The difference is not of one degree, but of kind. The SNP profile and the IgG was used to develop a lead, not to demonstrate substantive evidence of guilt. On the other hand, the STR analysis is substantive evidence the state intends to use at trial to prove its accusations against the defendant. As demonstrated in the figure below, the DNA tree, I'm calling this. The STR analyses and the IgG based on the SNP profile are distinct processes. Okay, and this, don't worry, this little visual right here, this IgG tree is going to be in the video presentations that we're going to watch here very soon. And don't worry, it's going to be, I have it to where it's clarified, like you can read it easier. It's going to be zoomed in, and it's going to have stuff highlighted and circled. It's going to be great. Julie, that's funny. Wrong stream. Awesome. I know you, Julie Fru's in the UK. You're in England, right? Right, my friend? American Prince is saying, I'm glad you're explaining why the word place was used, and I agree with that. Yep. I mean, it's standard languaging, right? Because they're not, yeah. Anyway, I already explained it. So yes. Okay. So we're gonna come back to this because it's gonna be in the video, but here, let's keep going here. So as Rylene Nowlin, the laboratory manager of the Idaho State Police Forensic Services Laboratory, explains in her affidavit filed contemporaneously with this reply, STR and data and SNP data cannot be directly compared. When the lab does an STR analysis, it does not require submitting agencies to notify the laboratory how a suspect was identified in a case. This is like a straw man argument, right? Because that's not what they're asking for. They want the IgG, which is the SNP. But anyway, that's, you guys keep going here. Because how a suspect was identified has no effect on the laboratory analysis. Right. When it comes to the STR, okay. It also has no impact on the statistical calculations performed when doing a direct comparison of the reference sample STR profile with the STR profile developed. Right. Like, notice, guys, STR. You know what it has nothing to do with? The IgG. Okay. Though defendant also asserts that it is rather obvious that subsection B5 applies to the IgG information, he again fails to articulate how that follows from the language of the rule. Instead, defendant criticizes as puzzling the state's assertion that Rule B5 does not require the state to disclose what investigators do with the results or reports from scientific experiments. Far from puzzling, that conclusion is compelled by the plain language of the rule, which simply requires a disclosure. Okay, And then I feel like this is the part where there's something interesting in here. Okay. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy any results or reports of physical or mental examinations and of scientific tests or experiments made in connection with the particular case that are in possession, custody, or control of the prosecuting attorney, or the existence of which is known or is available. You know what? I can already see what you guys see where this is probably going to go. I'm just thinking here. You can see where this benefits the state, right? That the FBI did the IgG family tree. Don't worry, we're going to get to it. And that poof, they delete all their work because that's what they do, and they can't show anything for it. So, okay. Under defendant's novel theory, this subsection will require the state to disclose everything down the investigative stream from a scientific experiment, regardless of its relevance at trial. The authors of that subsection could have included that requirement, but chose not to. And then here we have the subsection from B6. On written request of the defendant, the prosecuting attorney must furnish to the defendant a written list of the names and addresses of all persons having knowledge of relevant facts who may be called by the state as witnesses at the trial, together with the record of any prior felony convictions against any of them. That is within the knowledge of the prosecuting attorney. The prosecuting attorney must also furnish, on written request, the statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents to any official involved in the investigation of the case, unless a protective order is issued. So two ways that the state can get around turning over IgG here, just from this subsection, right? One, right, this part where it says within knowledge of the prosecuting attorney. So we've seen them do this, again, just literally, if you've watched the hearings, you've heard it. You've heard the state say, we don't know where it is, we don't know who has it, blah, blah. And again, when we get to the video, that one of the videos that's titled who did what when, we're going to see more of that. And remember, when I said keep in mind, where did it go? This part, the expert relying on the work of unnamed others. Here we are, January of 2025, and when it comes to expert witnesses, and we're getting some more of this, right? Okay, so now that's the first way they can get around it. The second way, right here, unless a protective order is issued. And the irony that this is the reply to their motion for a protective order, because literally that's what they're doing. Okay. Defendant fails to explain how anyone involved in the IgG related to this case constitutes a prosecution witness. Or prospective prosecution witness. And the state's motion makes clear why that cannot be the case. The state does not intend to present the IgG information at trial. Again, like let's see if we can help prosecutor Santa out, right? Remember, they are referencing subsection B, which is funny because they've already said, as best as state can tell, the defendant is not asserting that B or C apply. So then why are you still arguing subsection B? The defense is not arguing that, and you've already said they aren't. This, right? Again, it's the same thing. They're doing the same thing as they've done before, like we just talked about, where they're not addressing the actual issues, they're addressing the non-issues, right? Material to the preparation of the defense. That is the reason. But yet here we are. Let's go back to where we were. Where was it? Here. And the state's motion makes clear why that cannot be the case. The state does not intend to present the IgG information at trial. That's subsection B. And they've already said that they know the defense is not arguing that. It leaves me at a loss, guys. The plain language of subsection B8 is equally problematic for the defendant. On written request of the defendant, the prosecuting attorney must furnish to the defendant reports and memoranda in possession of the prosecuting attorney. Again, look, it's in italics, right? So we don't have it. We don't have it is an excuse, unfortunately, that were made by a police officer or investigator in connection with the, and you guys keep all of this in mind, because when we get to these videos of who has what, who did what, when, it's really shocking the way I have it lined up back to back. It's shocking, really. And this is what they're relying on. Nobody has it. We don't have it. But not only that, the police officers don't have it. The nope, literally, it doesn't. Nobody has any of it. Okay. Again, This subsection only, they're saying it again. This subsection only applies to records in the possession of the prosecuting attorney, and the state, there it is. What was I just saying, guys? The state does not possess the FBI's records related to IGG. Keep that in mind, because there's going to be a question in the video of why certain things happen and why certain things happen related to the FBI. And this might come in handy, okay? I think there's one other little thing. Let me look here, because I really want to get to the videos, but we are going to finish this. Let's do that. We'll come back to this. Let's pull up. Let's start with the video, the who did what when. Okay, because we've just been talking about it. Okay. And I've not even been looking at the chat, but oh, that's awesome. And I'm so glad. Is Flashfan, is he still doing that live stream? Good. I hope it's going well for him. It seems like he's doing a good job with that, and love it for him. Oh, that's funny. Yeah, right. Same here. And I'm not sure what you're referencing, because this is from a while ago. I wasn't able to see the chat, so I was reading my documents, but the standard language. Are you talking about the placed part there? Okay, so let's pull up. Are you guys ready? I'm super excited. Okay, let's start, y'all. I think this is going to be awesome. I'm excited. All right, let's start with this. Okay, so keep in mind, like I was just saying with the expert witness, right? That relying on the work of unnamed others, and then we don't have it because the FBI doesn't have it, and neither is law enforcement. All that, right? Okay, ready? Who did what when? Right. One last thing. As we listen to this, guys, I want you guys, because y'all are all trial watchers, I want you guys to imagine, because what we're hearing here, when they ask these questions at trial, this is what we're going to hear. So what I want you guys to imagine is, imagine that you're watching a trial, and imagine this is the testimony that you hear. Imagine it. And we've all seen billions, or well, whatever, lots of law enforcement officers, detectives, especially when it comes to like the lead detective. We've all seen it. And I want you guys to imagine that this is what, because this is what we will be hearing at this trial, okay? From these two people. Imagine that this is what you're hearing.
Detective Mowery, did you take part in the investigation into the homicides on King Road?
Yes.
And what was your role?
A lot of different things. How to answer that.
The report that you wrote and that I received today, when did you learn about those documents that exist according to that report?
It was such a lot that I found from yesterday.
Yesterday.
Why did you come to find them yesterday?
I was preparing for this hearing.
Okay. And those are things that existed for quite some time, is that correct?
They did.
When you wrote about your work with CASBIZ in May of 2023, did you document those items?
No.
All right. Tell me what you found when you were preparing for the motion to compel today.
I found session logs that were sent to me from the FBI.
From the FBI.
Did you look at the CASBIZ 48-hour file?
I don't remember if I did at the time of reception.
Did you look at it yesterday in preparation for this hearing?
I attempted to.
All right. And how about the CASBIZ full log?
I attempted to yesterday.
JSON files were produced by CASBIZ. Is that right?
I would assume that. I didn't create those files.
What date were they created?
I believe one was in December. The other was in April.
Could you tell who created those?
I could not.
How did you get those?
I was provided those via email.
By who?
Nick Balance of the FBI.
What did you do with those?
I gave them as soon as I realized they were in my possession. I had contacted the prosecutor and gave them.
And that would be just yesterday, is that correct?
Yes.
What did you do with them prior to that time?
They were sent to me. I put them in a folder and I didn't do anything else with them. That's why I forgot them.
Okay,
Got them.
and that was the 48-hour file?
48-hour session log, yes.
How about the full file? What was contained in there?
Similar items to the 48.
What is the full file?
I believe that was the second AT&T return that we got via warrant. I wasn't able to open it to verify it.
In the report that I just received today, there was reference to a loped bar file. What's that?
It is a file that I received from Agent Downs.
When did you receive that?
Yeah,
I want to say the modification or the email. I honestly don't remember. Unfortunately, it was yesterday and I've been throwing this stuff together. So,
Okay. So that was one that you just found yesterday?
yes,
Okay. Did you open that?
I don't recall opening it. But I did. I don't recall doing it.
guys.
How about the CDR.xlsx file? Was that, and CDR, what does that stand for?
All detail records.
Did you open that?
That's like, at least he can answer that question.
I don't remember if I did not.
God.
Did you open it yesterday?
I don't remember. I was looking for. I
She's trying to help him out there because so far the questions that he's able to answer, if he's able to answer them, they're all, I did it yesterday or I got it yesterday. So she's trying to help him out here. Well, was this yesterday? Because it seems like you did a lot yesterday, but like that's not helping him. I mean, she's trying to help him out.
Did you open it yesterday?
I don't remember. I was looking for. Once I found them, I was trying to figure out how they came into my presence or in my possession. That's where I started to focus.
Okay. Did you use that file? Well, let me ask this first. That file that contains code, do you use that with the CAST biz program?
I attempted to load the section file in its entirety and it received errors, so I was not able to. That's why I went into the JSON file to see if there was something I could see reference.
Is that file usable?
I'm sure it is somewhere.
Watch Judge's face.
What is the restriction for you?
I don't know what restriction it is. I don't know what to do with that file outside of, if I could possibly bring it into the CAST is. I tried to pull it in as a combined session log, which is what I was trained to do. So I didn't get that. I didn't pull that file.
How many times did you use the CAST biz program in relation to Bryan Kohberger's call detail records?
I don't know.
More than once?
I recall doing it for the grand jury because I wasn't the main lead in the call detail records investigation.
I don't understand what that means.
I wasn't the main person looking at those call detail records.
You weren't the main person with the call detail records, but you put them in the CAST biz program anyway?
For the grand jury, I was requested.
Okay. You weren't the main guy with the call detail records or with the CAST biz programming. Did I understand that much right?
There was another investigator that was doing that.
Okay. But you end up involved in it somehow in April of 2023, is that right?
That's when I was asked to examine the data to provide that for the grand jury.
Okay. Was that all of your instruction?
What do you mean by that?
What do you
Well,
mean?
you're asked by somebody else who's actually doing this part of the investigation in the case to produce something for the grand jury to use. And I'm curious about what you relied on, what you, to get to that point. I want to know all the records you relied on, all of the emails, all of the conversations you relied on to produce this thing that you're not the expert for.
So I wrote the affidavit for the AT&T records, received the AT&T records. Those records were also given to another investigator who was the main investigator doing the CDR records. Prosecution then asked me to provide or create some type of visualization of the call detail records and examine the call detail records for the 4 hours in question. That
Were you the go-to person or the person in charge for evidence that would be brought into Moscow Police Department to support your case?
No, ma'am, I was not.
Couldn't agree more.
Who's in charge?
Also,
That would have been our evidence custodian.
As the lead detective, were you aware of the evidence that would be under the control of the evidence custodian?
Not entirely. I was made aware of basically the most pertinent evidence that was coming in, but was not aware of every single piece of evidence that was brought into the police.
Okay. During the course of, I guess, the investigation from November 13th
I guess the investigation.
forward, was there videos that were collected, like a video canvas done of the community?
Yes, ma'am, there was.
Is that something you were involved in?
No, ma'am, I was not involved in the direct collection of those videos.
Welcome.
Who is responsible?
I'm going to back it. So I just wanted to say hi to everybody. Welcome for you guys that are just now joining us. Again, we're asking ourselves here, who did what when, but also I asked everybody at the beginning of this, imagine if you were hearing this testimony at trial, because we will be hearing, I mean, not all of these questions, but a lot of these questions are very basic and they come in. It's chain of custody. That's what this is. This is chain of custody. So imagine hearing this at a trial.
Videos that were collected, like a video canvas done of the community.
Yes, ma'am, there was.
Is that something you were involved in?
No, ma'am, I was not involved in the direct collection of those videos.
Who is responsible for the video collection and knowing what videos exist?
So the way that worked was individual investigators who went out in the community and collected those videos,
The question was who? And he says, the way that worked was,
brought them back to the police department and provided them to our digital forensics office. And then they were later booked in through that channel.
that doesn't
And who is that person?
That was a joint effort between Detective Mowery and several people within the FBI.
Which people within the FBI?
I do not remember.
Oh,
I have a specific one that a couple of them I want to ask you about. One is from Red Star Coffee Shop. Do you recall receiving that video?
I do not.
Okay. And are you aware that it was booked in or brought in by Idaho State Police?
Not.
oh my God.
How would I find out about those videos?
I don't know. You would have to go through the USB drives to find out what was given. I was just given the mass USB drives. I was not given them by the people that were bringing them in for time. Given to them after it had been handed off to other investigators and other assistants that were helping bring copies.
Is there somebody else I should ask about specific ones to track where they went?
I don't know. I
Excellent.
don't have that information.
Excellent.
Okay. Detective Payne, I'm asking because last week, Detective Mowery told us that he wasn't in charge of these videos. And
Oh,
I need to know where they are. Do you have any idea who the FBI agents are that were also in charge of this?
so
We could certainly find.
just to break this down even more clear. So Brett Payne says, well, Agent Mowery was in charge. He did the video. Well, when she asked Agent Mowery, that's why I played those clips back to back. Agent Mowery was like, I don't have it. I don't know. I don't know anything. And so then she's like, well, what about, oh God, it's
I
just,
need to know where they are. Do you have any idea who the FBI agents are that were also in charge of this?
We could certainly find that out for you, yes, ma'am. I don't know off the top of my head.
incredible.
And so you collected business videos or had that done, but who I need to talk to about this would be Detective Mowery or an unnamed FBI agent. Do I
Or
understand that?
The agents who were the officers, investigators who collected that specific video would have written reports, to the best of my knowledge, stating such that they collected video from X, Y, and Z. That would be the best person to speak to about that particular video.
But if they collected it and gave it to Moscow Police Department or
Made the joke, right? That it's a bunch of ghosts working on this case. Like, this is, y'all.
the digital evidence people, isn't it your department that I'd be looking at and say, where is this now?
Yes, ma'am.
Oh my God.
First, the affidavit. What did you rely on in the affidavit you wrote for the first AT&T search warrant on December 23rd, 2022?
It was a conglomerate of interviews, data received from cell phones, my observations of some surveillance footage that was taking place, various other things.
Various
Go
other.
down the line. If you could be more specific on specific parts, I'd be happy to tell you what I'd like.
Okay. Well, you told me that you're not the guy who understands how to interpret these records. Do you know anything about cell phone towers?
Very little, ma'am.
I mean, again, imagine, guys, are you guys imagining hearing this at a trial? It seems like a parody or like a meme, or, I mean, it blows. This is the lead detective.
So when you wrote the second AT&T warrant, you have possession of Bryan Kohberger's call detail records or AT&T records, but you don't know what they mean, so you're relying on somebody else.
Yes, ma'am.
Oh,
Who all did you rely on?
Mainly it was Special Agent Balance. He was my main point of contact for understanding what was going on.
I mean,
Okay.
really, the only people that either of these two law enforcement, the only person they can name is Agent Balance, and that's it. Otherwise, it's just it's the ghosts, right? As I've been calling them. But what does that say, though, to you guys? That, like, it sounds like Agent Balance did like literally everything, right?
What I want to know is what you relied on to get that first one that talks about WSU and the cameras of WSU. So where'd you get that?
Yes, ma'am. So Special Agent Rob Hilley with the FBI was also co-located with us.
Now we're going to be do now get a second name, thank God. Rob Hilley from the FBI.
He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
And from the FBI, we have Agent Balance and Agent Hilley at Moscow Police Department with you. Yes.
Yes, ma'am.
And all of this work is done with verbal communication. Is that right?
The majority of it, yes, ma'am.
And
I mean, this verbal communication.
Nick Balance's cast draft report.
Correct.
And I think Special Agent Imel's vehicle identification.
Yes, ma'am.
Okay.
Right, Agent I'm.
Is there anything else you relied on to obtain that second search warrant to compose your affidavit?
Like I said earlier, we relied on cell phone records from surviving roommates as well as the victims. We relied on interviews with the two surviving roommates that were present at the time. We relied on the surveillance footage, cell phone data. I'd have to go paragraph by paragraph, but that's
Like, the surveillance footage that, like, they didn't look at and they didn't obtain, and like the cell phone data they don't know how to interpret.
what comes to mind.
Of those things, are you relying on other people's work to
There it
put
is.
that all together?
Yes, ma'am.
Okay.
There it is. Other people's work. Other people's work. Right? Like I was referencing when we went through those filings. Other people's work. The ghosts, as I'm calling them. Okay. Next part. White Elantra versus DNA. Now we're going to go through there's going to be a whole calendar. Just wait. A confusing race to the finish line. And also Gwennon making a great point here. Remember, your teachers show you work. Right. I know. There's literally non-existent in this case. It's incredible. Okay. So here's the first calendar. So I've got calendars for November and December. Now, these calendars are obviously not everything, right? However, when I say everything, there's very few dates given in the actual information from the state. But as it pertains, right, to to the DNA and the white Elantra, right? Like I said, like it said, the race to the finish line. So that's, you know, the only, of course, Thanksgiving, right? That's just as a reference point. But okay, so this is this first week here after the homicides. The first date that we have, MPD asked law enforcement to be on the lookout for white Elantras. Okay. All right. So this is taken from the affidavit here. Law enforcement officers provided video footage of suspect vehicle 1 to forensic examiners with the FBI. No date, obviously, as it says. And then that regularly utilized surveillance footage to identify the year, make, and model of an unknown vehicle that is observed. Now, here's why. Let me back up a second. Why does this matter? Because there's no date here, right? But check it out. So here's the thing. So on the 25th, MPD asked law enforcement to be on the lookout for white Elantras. So that means that by the 25th, right, they at least knew they were looking for a white Elantra. Okay. Now let's go back here. Okay. So the part that we don't know, again, when did they provide it to the FBI? Okay. No date. That regularly, blah, blah. The FBI examiner, of course, we know now it's Agent Imo, but they don't name him in this, which is another thing. His specific training, okay, whatever. Okay, after reviewing the numerous observations of suspect vehicle 1, so one of the things that we're going to be charting here is when did the years change, right? So after reviewing the numerous observations of suspect vehicle 1, the forensic examiner initially, no date, believed that suspect vehicle 1 was a 2011 and 2013 Hyundai Elantra. Upon further review, no date, he indicated it could also be a 2011 and 2016 Hyundai Elantra. As a result, investigators have been reviewing. So part of what I was doing when I was going through this was I was trying to remember at the time, right? When all this was going down, I was trying to remember, did we ever hear that this was announced, right? Like that they expanded the years. Like we all remember probably that this 2011, 2013, but this part, right? That they expanded the years. And I was like, I don't remember that, but that's part of what I did. I went through all the documents and I also went through, as we will see, actual footage from the time. And okay, so let's keep going. Because remember, if you're doing a BOLO, okay, first of all, if you're doing a BOLO for law enforcement alone and you change the years, wouldn't you want them to know that? Second of all, if you still don't have the car that you're looking for and you're asking for the public's help, wouldn't you also want them to know if you've changed the years, right? Okay. Investigators were given access to video footage on the Washington State University campus. No date. A review of that video, no date, indicated that at approximately 2:44 a.m., suspect vehicle 1, this camera footage from Pullman, Washington, was provided to the FBI, the same FBI forensic examiner. Again, they don't name him, but we know now it's Agent Imo, but it's just weird that they don't name him. But also, no date. The forensic examiner identified the vehicle observed in Pullman. This is the key part here, as being 2014 to 16. No date. No date. I mean, never seen anything like this in my life. Like when you actually go through it and look for dates, like it's even worse than it seems, from just reading it. Okay. Now this is the Othram invoice, okay? So date of issue, November 29th. And you'll notice here, we already just saw this name earlier tonight, didn't we? Rylene Nowlin. They were quoting her in the states. That's the reply that we were just reading, actually, before the video. So, and for anyone who hasn't seen this, okay, this was obtained by Kevin Fixler of the Idaho Statesman. And so here you see a Rush FGGS, that's Forensic Genetic Genealogy, SNP S&P panel, right? And then Idaho State Police contract. Okay. So, and as to this, don't worry, I've also got something else we're going to talk about that pertains to the car with that as well too. So, okay. So there we have it. So due December 29th. So why did I include this? Because we have so little information for the timeline, right? But the fact that they sent the invoice and it was issued November 29th, that would look like, right? What can I glean? What can we glean from this logically, right? Best we can do. That you would imagine that the Rush S&P panel was already finished, okay? And that this contract that doesn't specify anything would be for whatever they are then further asked to do. What could that be? Well, that could be building a family tree. Don't worry, we will get to it. That could be doing the IGG work, right? That where you go through and you try to find family members. So this is just getting the S&P panel. But this, again, being non-specific, would be whatever else is needed. But the key point being that they have the S&P panel, I would imagine, right, is completed because it was a Rush panel, and that's done by this date. Okay. All right. On November 25th, MPD asked, this is the BOLO, right? To be on the lookout for white Hyundai Elantras in the area. On November 29th, same day as that invoice, right? At approximately 12:28 a.m., WSU police officer Daniel Tiengo, so at least we have a name here, queried white Elantras registered at WSU. Now, one would have to imagine that the reason he did so was because of the BOLO, right? As a result of that query, he located a 2015 white Elantra with a Pennsylvania plate. Now, remember, they were only supposed to be looking for 2011 to 2013. So he locates a 2015 white Elantra. This vehicle was registered to Bryan Kohberger. Now, here's the thing. So if you presume that he's searching for white Elantras and the BOLO says 2011 to 2013, right? But he finds a 2015 one and he doesn't discard it. He doesn't eliminate it from the list. Is there a reason for that? Like, why would, like that, the thing that makes logical sense is if you see the name of the person, right? Because he could see who it was registered to. That you see the name and you're like, oh, that's like, in other words, if you were thinking the other way around, like, for example, if you had a name and then you're like, what car does that person have? The other way around, right? But if you don't have a name, but all you've got is you've got the car, 2011 to 2013 white Elantra, then why would you then not eliminate a 2015 unless it was something to do with the name? This is just logical thinking, okay? Residing. Now, this matters, right? So there's a reason I highlighted it. The vehicle was registered to Bryan Kohberger, and it had his where he was residing, right? In Pullman, Washington. Okay. Next. That same day. Now, this is almost that weirdly with me, guys. That same day at 12:58 a.m. Wait, hold on. Let me go back. So 12:28 a.m. Check this out, okay? So 12:28 a.m., 30 minutes later. What are the odds? 30 minutes later. 30 minutes after Daniel Tango queries white Elantras. Now remember, and this is the same day as that invoice, right? Same day as the invoice from Othram. And after the BOLO, November 25th is the BOLO. So on November 29th, why on that day? Why on that day, 12:28 a.m., he queries, okay? Now, 30 minutes later, what are the odds of this? Curtis Whitman is looking for white Elantras. Like he's just driving around looking for them randomly, like without having talked to the first guy, right? Like these are separate events. My brain, this has never sat right with me. These are separate events. It does, like they didn't communicate. There wasn't, at least it's not included here, right? It would honestly be better if it was, because then it would make more sense. But, and noteworthy, right, is that again, this gives the address, but it gives it to Mr. Tiengo, okay? Now, you've got, just by happenstance, Mr. Whitman, 30 minutes later, just driving around looking for white Elantras at night in the dark and locates a 2015. Now, remember, it's odd enough. There's a number of reasons why this is odd, but let's just not forget that the year that they're supposed to be looking for is 2011 to 2013, right? and he just happens to see this. Officer Whitman also ran the car. So again, this right here supports, like I was just saying, that he didn't hear from Mr. Tango. They didn't communicate. This is happenstance. On this day at this time, 30 minutes apart. And it returned to Kohberger with a Washington tag. And then again, here's no date here. I reviewed. Now, this is the part that I've talked about this a lot, right? This is from Brett Payne saying I, okay? Because in his testimony, as we're going to hear in a second, he says that this is the 20th, December 20th, right? But where this is included makes it seem like it's the same day, does it not? Why would you put this here otherwise? But the fact that he doesn't include a date, in a way, it's like he's giving himself plausible deniability for later on. Like, but the fact that it's right here, like you include it right after this. Anyway, okay. So Officer Whitman also ran the car and returned to Kohberger with Washington no date. I reviewed Kohberger's Washington State driver license information and photograph. This license indicates that Kohberger is a white male with a height of blah, blah. So the other thing, I did a bit of research, and from what I can see, if you run a plate and you get their registration information and stuff like that, it doesn't give you the driver's license. Now, could that have been provided because of the affiliation with the school and being like, you know, whatever in student house? Maybe, right? But in other words, when he testifies, though, he makes it seem like that's when he also gets the license, as you will hear. We'll listen to that again. We'll hear it. So, hey, Frank's glad you're here. I'm glad you're here because we have not yet gotten to the IGG family tree, and I'm really excited for your input. So, okay. For anyone who doesn't know Frank's has recently been admitted or accepted into a program for doing IGG. Okay, so now we add this to our calendar. So now what happens is, see, it's going to make big the week that we're on, and then everything else we already included is smaller, if that makes any type of sense. So on the 29th, you've got 3 bullet points. Othram invoice. WSU Daniel Tango queried white Elantras. WSU Curtis Whitman drives by white Elantra at student housing. Again, remember, these are the wrong year, but they didn't exclude it. Okay. Now we're going on to December. Okay. Now I included these calendars back to back for a reason. Because here's why. Let me go back. So look at this, guys. November 25th, the BOLO for white Elantras, right? And then you've got these WSU, Washington State people doing things with the white Elantras here, okay, on the 29th. But there isn't it's not publicly announced until the 7th. And again, you can see it right here. And it's going to show us, we're going to see the announcement thing here in a second. So 2011 and 2013, again, that's the year range, right? Publicly announced as a vehicle of interest. But what doesn't make sense here, guys? Do you see why this doesn't make sense? Because why do this? Help me out here. If right here on the 29th, right, you already have them, 2 different people separately without talking to each other somehow, identify a 2015 white Elantra and associate it with Bryan Kohberger. And again, it still doesn't make sense as to how that happened, because the year 2015, it should have been eliminated. They didn't eliminate it. Which again, like I just said, it's almost like, was it because of the name? It doesn't. But if they've already found it, then why are you announcing, like, this is to get the public's help, right? On the 7th. And I went back, guys. I watched every single one of the interviews with the law enforcement from the Moscow Police Department on every single one of the days from the homicides, okay, like until the 7th. Actually, I watched all of them, but in terms of the time, because what I was looking for is, is there any mention that they might have a car in mind, but they don't have more information yet? Like, was there any whiff of a vehicle until the 7th? Even if it was just in general, right? Considering on the 29th, you already have this business. And I also went back through all of the announcements, you know, and we're going to see the one in a second here, right? The public bulletin things, right? And here's what's so interesting. On the 6th, they had both. They had a bulletin thing update and they had another like interview thing. And there's literally no mention anything about a car, nothing at all. Zip. They're like in the dark entirely. Okay. Then on the 7th, after all the business we already looked at on the 29th, then they announce it publicly. And the reason is because they need the public's help, right? And it's a 2011 to 2013. Okay. The brows, that's funny. Okay, so here it is, the press release, right? December 7th. Police are asking for the community's help. And he says here, they're interested in speaking with occupants of a white 2011 to 2013 Hyundai Elantra with an unknown license plate. Now, remember, as we saw on November 29th, they had a license plate, the Washington, the WSU people did, okay? They had the license. Coincidentally, 2 different officers, 30 minutes apart, right? And his registration and his name, okay? Tips and leads have led investigators to look for additional information about a vehicle in the immediate area of the King Street residence during the early morning hours, blah, blah, okay? Here's some stock photos. Now, don't worry, we're going to get some more images here in a sec. Now, I compiled this, obviously. So this is sample vehicles, right? So this is 2011, 2013, because that was the date range that was given. As of yet, we've not heard anything about a date range being expanded. I mean, it was in the affidavit, but we've not seen that going back in time. Again, in the public announcement, it's still 2011 to 2013. And then again, on the November 29th, you have them finding the 2015. So anyway, then here's 2015 and here's 2016. So I'm not like an expert to be able to tell these apart, but apparently people that are car experts can tell them apart. So in other words, the thought being like, if a vehicle is from 2015 or 2016, would it have been that easy to mistake it as a 2011 or 2013? So any of you car people in the chat, feel free to weigh in, but that's pictures of them. Okay, so now we're going to take a step moment. We're going to go back in time. This is from December 16th. Now, this is not the only thing that happens on this day, so wait for it. But this is from December 16th. So again, me going back in time, I went back and I was like trying to see what was really, refresh my memory, what was really happening at the time. What was the word on, because again, they're asking for the public's help, right? So did they mention anything about expanding? Like what was, so now we've gone from December 7th, now we're on December 16th. So now, what is the information that is being released to the public? So this is Vinnie Politan from Court TV, and this is just going to take us back in memory lane here, a little snippet from about what was it that that mainstream media, you know, what was sharing with the public, and just so we can have a little bit more of like, you know, remember what it was like back then. Okay.
Time's running out. Investigators are on this. They're putting resources towards it. There is pressure, obviously, to solve this case. Number one, for the families, for a sense of justice, and then for the entire community for a sense of safety. And some mass murderers not running around loose. So they know it's a 2011 to 2013 white Hyundai Elantra.
Again, so here we are, December 16th. That's still the information. Okay. 2011 to 2013.
Time's running out. They're going to track everybody down that has one of those cars. Might as well come forward now. Investigators are working this lead. They are working it, putting resources behind it, asking for more help from the public, and all those people that want to help are going through security footage. They're looking for, you know, is there anything from that night, from that day, the day before? Trust me, they're checking everywhere.
And it's really sad because like that would be a logical thing to think, but we just heard from in the motions to compel, we just heard from that. And, you know, the questions about the surveillance cameras or the video footage. And what did we hear? Nobody knows who's in charge of any of it. And nobody knows anything about where it went. And it's just,
Anywhere where there's a camera around there, people are checking their footage, looking for that white car. First, let's hear from the chief.
Through our tips, through our leads, some of the evidence that came in, we start to identify patterns. And like we said earlier, we are confident that the occupant or occupants of that vehicle have information that's critical to this investigation. We also understand that even though there's sometimes a fascination with a particular case, some people simply don't see the news and may not know that we're looking for it. So if we get the word out there, hey, maybe your neighbor has one in the garage that they don't drive very often. Maybe there's one that's just not on the registration database. Let us know. So far, we have a list of approximately 22,000 registered white Hyundai Elantras that fit into our criteria that we're sorting through. That's an awful lot of information, but it may not be all of them. So
remember, at this point on November 29th, you already have, again, those two separate police officers from Washington State University that already identified. Now, again, we don't know why they identified it 2015, because that's not the years that they're supposed to be looking for, but they identified it, matched it to Bryan Kohberger, got his registration, got all his info, right?
the public can help us with that.
22,000 fitting that criteria. I didn't realize there were that many white Hyundai Elantras from 2011 to 2013. I think about 600,000 were sold in the whole country. Anyhow, let's bring in Chanley Painter. I was so excited. Chanley, great to see you. What do we know about the tips for this car? To me, this thing is heating up. I feel like there is some sense of momentum here. What about the tips?
Yeah, I mean, the tips are pouring in, Vinny. Police saying they worked overtime over the weekend, 24/7, trying to find the occupant or occupants of that Hyundai Elantra seen near the crime scene. We don't know how they know about this vehicle. They haven't released that many details, but they believe the person inside or the persons inside have critical information. And so we learned through a Fox News digital report on Tuesday that, yes, those local businesses, those working around the area are just pouring through their surveillance video. And so
sadly, some of that surveillance video footage is like lost, and they say they don't, they claim they don't know what happened to it or where it can be found.
Fox News digital report, detectives collected 8 hours of surveillance video Tuesday morning from a gas station in Moscow where a clerk saw a white sedan passing by at 3:45 a.m. on the night of the unsolved stabbing deaths of 4 University of Idaho students, according to store workers. An overnight assistant manager told Fox News Digital that she's been reviewing the tapes a little bit at a time over the past few days, looking for clues in her downtime on the graveyard shift. She said she was not working on the night of the actual murders, but
also, like, you've got a gas station clerk doing law enforcement's job here, right? She's reviewing the tapes a little bit on her downtime during the graveyard shift. Incredible.
Car in this video from this gas station drove by real quick.
And that to me makes it sound like, in other words, because of asking for help from the public, it was her initiative to go through and look at the videos and see if she could find. And she's like, oh, I found, not that law enforcement asked for the surveillance footage and found it. Right? Isn't that what that's, I mean, literally, like, it's great. Like, in other words, this right here is showing just how great the effort, right? The community's trying, the community wants to help. They're looking, but the thing is that it's easy to forget. Well, but that's wasn't law enforcement supposed to be doing that?
She said,
if they weren't,
and turned down a side street off Highway 8. So this was huge, of course. I mean, this is someone working on their downtime, pouring through. This is how interested this community is in trying to find this white Honda Elantra, Vinny. And we, of course, still have that video of that location because that would have been the first major spot that I'm sure police went to and confiscated a lot of their surveillance video because it is so close to where that home is, where those 4 students were murdered. So here you can see on one side.
They didn't go to the gas station, and then the other places that are right near it, like there's that Red Star coffee place, like we don't know what happened to it.
The screen As we pass the crime scene there on the left side of the frame, we're exiting a dead-end road. We're pulling out. It's very residential, a lot of students. Right here, you can see the campus. There's the Sigma Chi house right there in the shot. At that intersection across the street, there's Band Field, where we've seen a lot of body cam video from. On the night of the murders, we're passing on the left side. And then you move campus on one side, on the left side, neighborhood apartments, homes on the right side, off-campus housing. And we continue down this main road until you reach that main gas station that we showed you. That was the closest one. Do they also have video of this white sedan? We don't know. Police aren't saying, Vinny, but it is pivotal that they have this new clue that was revealed through that Fox News digital report.
And Janley, there's the gas station. We can see it right now.
Okay. Like I said, something else happens on this day. This is where it gets crazy, right? So that video we just watched again was from December 16th, right? On Court TV. On the 16th, Kohberger was observed entering a CVS in Pennsylvania, and his email and phone number was somehow obtained by law enforcement. So you guys see the problem here? Like what Moscow police MPD is saying is like, all we've got is we're looking for a 2011 and 2013 Hyundai Elantra. That's what we're looking for. We need help. They're making a plea to the public. Please help us find this car. Meanwhile, again, like I said, on November 29th, you already had that was, identification made from like the WSU people, but never mind that. On December 16th, law enforcement, doesn't specify who, but I would assume it's the FBI, are already following him going shopping in Pennsylvania, nonetheless. And this was in one of the motions to suppress. I think it was about Google, but in other words, that's how the email and phone number was obtained, because of him going into the CVS. So it's like, what is happening? You guys see where this is crazy? Like, ostensibly, the FBI, right? They've already identified him. They're already tracking him. You know what I mean? But yet, MPD is like, got nothing but a 2011 and 2013 white Elantra. Okay, so now here's our updated calendar, right? So there's the 7th there, and now you can see on the 16th, BK is observed by law enforcement at a CVS in PA. I mean, ostensibly, one would think, right? Ostensibly, the FBI, like, why were they doing that? Is it because, like, what information got them there? Was it, like, the question would be, remember, the Othram invoice from the November 29th, right? How did they get here? It's not MPD, right? It's like the FBI, I would assume, right? How did they get here? I'm circling with my mouse. I don't know if you guys can see. Was it because they heard from the two officers from November 29th, Tiengo and Whitman, and they were like, hey, blah, blah, right? But then again, you have to ask yourself, like I kept saying, but how come they didn't eliminate at 2015? Like, to me, the fact that they didn't eliminate 2015 back then, right? Like I said, it's almost like if you were going from the reverse, like you have the name first and then you look for the car. So then how did they get the name? If that's what happened. Either way, regardless of them, right? We know that his name has already been provided. But what we can probably say is, so again, we're still thinking like, was this from the car or something else, right? So we're going to keep taking a look here. Okay. Two more things of note. According to the police, they had said, okay, so this is the part here. Okay. This is what I wanted. So this is from a recent filing. The state had identified Mr. Kohberger on December 19th through IGG. So now we're talking about Idaho. Like, guys, the state Idaho identified him on December 19th through IGG, but you have him already being tracked in Pennsylvania on the 16th. And then you have the dad trash. Now, oh, I meant to say something too. So it's clear to me that when they did the dad trash, and this actually is a really important thing, right? When they were grabbing the trash, obviously they were hoping to get something with his DNA on it. Now, why is that? We will talk about that. We're going to take a look at the IgG tree. And they didn't get that lucky. They got his dad's, right?
Your affidavit talks about WSU officers finding white Elantras. And I believe there was an officer that you had some communication with. Do you recall the date you had that communication?
I do not recall the date.
Did you have some messaging system exchange with this officer to talk about that?
Yes, ma'am.
Is that the only means of communication you had with this officer?
No, ma'am. I believe I spoke to him on the telephone as well.
When you spoke to him on the telephone, how did that relate to the date of the messaging?
It would have likely been, if memory serves, it would likely been that same day.
Okay. Does December 20th, 2022 sound familiar to you?
Yes, ma'am.
And so this conversation with this officer from Washington, it related backwards to when he noticed an Elantra. Is that right?
Yes, ma'am.
But when he...
So here's the other thing. You guys, how does it make any sense that if in fact those two different officers on November 29th identified this white Elantra and identified it to Bryan Kohberger, and then you already have on December 16th, again, likely the FBI tracking him in Pennsylvania, following him to the pharmacy. Okay. If they already found, like, why a number of things, like why, if they found the Elantra or what they think is the correct Elantra, why then would they be issuing a BOLO, or sorry, in a public, right, announcing to the public that they're looking for this vehicle, what, like a week later or more than a week later? But more importantly, because there was the reason they were looking ostensibly, right? There was an internal BOLO. The law enforcement BOLO, right, was on November 25th. So if you're law enforcement, you get this BOLO on the 25th, you find a vehicle that you think might be important on the 29th, and then you don't tell anybody until December 20th, despite the fact that even if you just, let's just say you're shit at your job and you just like ignore it and you're just like, forget about the BOLO, like it's all over the news. There's the public, they announced to the public they're looking, like, how do you sit on that information for almost a month? I don't understand.
He noticed it. You didn't know about that yet. Is that also correct?
That is correct.
Okay, so you don't know about him or talk to him until December 20th, 2022, correct?
Yes, that's correct.
Okay, so now we have our calendar again, right? So there's the 19th. The state identified Bryan Kohberger through IgG on 12/19/24. That's from that recent document we just looked at, right? And then on the 20th, according to Brett Payne, he speaks with an unknown WSU officer and first learns of the white Elantra. And then I put in parentheses here, obtains driver's license, question mark, because again, in the affidavit, he doesn't give a date, but he makes it seem like it happened on the same day as November 29th. But he's, again, considering he just said that the first he ever heard of anything about Bryan Kohberger or the white Elantra was on the 20th, one would imagine that this might be when he obtained the driver's license. But still, what's missing, right? What's missing is they're looking for now a 2011 to 2016. So far, it's a 2011 to 2013 all the way through, with the exception of the WSU officers finding a 2015. But the expansion of the years is not announced or mentioned to anybody. Okay, now we have the dad trash, right? So 27th, 28th. And so now here's this on the calendar.
Time's running out.
Okay, so now let me pull up the next one. This is the IgG tree video. So, okay. You guys ready? All right. The IgG tree. So Franks is asking, when did he drive back to Pennsylvania with his father? It would have had to have been before the 16th. I guarantee you someone in the chat knows specifically. I don't remember. And I guess that came out because of the being pulled over, right? But like, that's not in any of the court filings, or I would have included it on my calendar. Because again, well, part of what I was doing is looking for dates, and part of what I noticed was like, there's so few dates given. So, yeah. But yeah, he was spotted on the 16th and just spotted. He was followed to the CVS, right? And they obtained his email address and phone number. Okay. So here's the IgG tree. Don't worry, we're going to break it all down. Break it down, break it down. All right. Once law enforcement had single source, this is from the motion for protective order. Once law enforcement had the single source DNA from the K-bar knife sheath, they conducted what is called an STR analysis. STR DNA analysis involves looking at blah, blah, blah. Okay. Law enforcement submitted the STR DNA profile obtained from the K-bar knife sheath to CODIS, right? No match was found. Unable to find a match using STR DNA analysis, law enforcement decided to use IgG to find a lead. Okay. So with that said, right, was CODIS first, then IgG. However, if you look at the state's tree here, right, guys, and if you look, so here to the left, SNP, so the things that this is supposed to be happening at the same time, right? At the same time, according to this, STR profile created by SP Lab. At the same time, SNP profile created by private lab, likely Othram, right? But look up here where the red circle is, right? STR profile used to search CODIS after sending to private lab. I mean, you guys see what I mean? That's above. I mean, I don't even know what to make of that, because that blew my mind when I noticed that, because I was like, what? They went ahead, like, not only had they, according to this, right? Not only had they already sent the DNA to likely Othram, but they already had generated an S&P profile. I mean, anyway, it's okay. This is important. In this case, investigators, of course, no names mentioned, or which agency, used IgG to begin the process of developing a lead to the individual who left the DNA on the K-bar knife sheath. The Idaho State Police utilized a private laboratory, right, to develop an S&P profile from the DNA on the K-bar knife sheath. The private lab, this is important. The private laboratory started using genetic genealogy to develop a family tree. But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the S&P profile to the FBI. So remember, because we looked at the Othram invoice, right? On the 29th, they already had generated the S&P profile. And then there's that, $4,500 charge for just Idaho State Police contract, non-specific. This is important. This comes up somewhere else too. It's in this video, so no worries. But so the private laboratory started using genetic genealogy to develop a family tree. But after law enforcement decided the FBI would take over. Now remember, what did we already cover earlier tonight, right? About the FBI. Well, actually, it's going to have it on here, so no worries. We'll get to it. Okay, so this is a footnote here, but for ease of reference, this motion focuses on the FBI's IgG efforts. The state is also seeking to protect the partial family tree created by the private lab, and it should be protected for the same reasons the FBI. So again, like I said, this is another mention of it, right? Partial family tree. That's why I have it. So they started, in other words, they got the S&P profile and then they did something with it. They didn't just get the profile and then hand it over. In other words, they would have entered it into a database, right? At the very least. And then the FBI takes over. Okay. All right. So now over here, can you guys see my mouse? So I'm on the left here. S&P profile submitted to genealogical databases. Now, I highlighted that because, well, we heard a lot about that in the IGG hearing, right? But also, remember, if you've got the S&P profile and you submit it into the databases, right? Remember those loopholes and the workarounds and all that we heard about in the IGG hearing? Okay. Now, genealogical research initially started by the private lab, right? As it says here. So then if up here it says search, so I added these 2 bullet points, right? Search results on or before November 29th as per the Othram invoice. Local law enforcement then decided the FBI would take over. Why? Like, why would they, like, that's the whole thing, right? They had them start the family tree. They had them start, you know, quote unquote, partial family tree. They had them start it, right? And then stop. And then further genealogical research would have occurred between November 29th and December 19th by the FBI. So the next thing you have to ask yourself, right, is that enough time, right? Franks, you might be able to weigh in on this, right? Like, is that enough time? Like, if that's when they first get, you know, like November 29th to December 19th, to build the family tree, enough to connect you to Bryan Kohberger. Meanwhile, we know, remember, and why do I say December 19th? Because again, that's the date given. So that's the date where Ann Taylor says that is when local, keyword being local law enforcement, got his name, a tip from the FBI, right? But again, remember, we already know that the FBI was following him in Pennsylvania on December 16th. Do you guys see where this is not matching up? Okay. The FBI uploaded the S&P profile to one or more publicly available genetic genealogy services to identify possible family members of the suspect based on shared genetic DNA. The FBI could then view the genetic genealogy services portal information regarding potential relatives of the suspect who left the DNA on the knife sheath. Based on the information the FBI could see in the genetic genealogy services portal, so that's supposed to sound really fancy portal. Literally all that is it's these direct-to-consumer databases that anybody can use. It's anyway. All right. The FBI went to work. They went to work. Doesn't this sound, look at this, guys. The FBI went to work building family trees. And they did all of this between, I've got so many dates in my head. It was November 29th. This is giving them the widest window, right? November 29th to December 19th. And actually, because of the fact that we know that they are already following him, I mean, that's the thing, right? It really is a shorter window than that because the 16th, they're already there in Pennsylvania. So, I mean, really, that window would be really small, right? They went to work building family trees of the genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor of the unknown DNA. Like, if they're already there in Pennsylvania on December 16th, how quickly did they do all this, right? Ostensibly. Because remember, we know the private lab started on it, according to what the state is saying, right? They started it, and then, so it would have been after the 29th, right? So, like, after the 29th, and then on the 16th, they're already there in Pennsylvania. But also, weirdly though, the tip is not given to local law enforcement until 3 days later. Right. So, and then by the FBI. So here at the top, right, defendant's name provided to local law enforcement by the FBI on December 19th to local law enforcement. That's MPD. So, I mean, it seems like there's other things going on that are like way ahead of the game, right? When you look at, again, the 25th, the 29th, the 16th, and then you've got like, it's like there's two separate investigations going on. And it just, because MPD is like completely out of the loop, completely behind. Like, they haven't gotten their tip yet, but he's already been found in Pennsylvania, right? And not to mention, it's still not until the next day when the lead detective first hears of the name Bryan Kohberger or the white Elantra. Okay, I might sneeze. Hopefully I won't. Okay, the genealogy conducted by the FBI resulted in a lead that pointed law enforcement to the defendant, but it did not result in the creation of many documents or records. Much of the information relied on by the FBI was only viewed through the user portal in the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records. So there's a reason I highlighted this and included it, because we know that there's the rule that tells them that they have to delete shit once they're done, right? The shit that they delete is the actual S&P profile. What does that mean? It means that once they're done, they remove that profile from the database. However, the results in the portal and whatnot that they got, that is not what it says. That they are not told. This is not protected by the rules, right? In other words, this is just, they just did not download it or create copies. This is not the thing that they're supposed to destroy or get removed. That's the S&P and like family names or whatever, but like what they viewed through the portal, like all this, like this is not the part that they have to remove. This is just that they did not download or create copies of those records. And also, like, look, it says it did not result in the creation of, because they didn't choose to, or they chose not to. That's the better way to say it. And why would that be, right? Okay. The FBI then sent local law enforcement a tip, right, on the 20th, even though they've already found him in Pennsylvania. Okay. On the 19th, rather. The IGG process pointed law enforcement toward defendant, but did not provide law enforcement with substantive evidence of guilt. The FBI did not, for example, conduct a direct comparison between the S&P profile from the knife sheath and the defendant's S&P profile. So why did I include this and highlight it in red? Well, that's true, right? I mean, but think about it this way, right? That's not what they're doing. They're taking the S&P profile from the knife sheath and loading it onto the IGG databases to come up with a name. This is like, again, replacing or switching out what the argument is, because this is not the thing in question, right? I mean, a direct comparison. So why is this in here? Like, would you, considering how quickly it looks like, again, if you look back on the 29th again, right? The direct comparison, right, may not have been, I mean, it isn't what's here in red, right? But in other words, can we glean from this that there was a direct comparison and that it was from the S&P profile from the knife sheath, but it was a direct comparison to something else, like, for example, a name on the database, maybe, because that's what the FBI was doing. Prior to the FBI's IGG efforts, the ISP laboratory developed traditional STR-DNA profile from the DNA found on the K-bar knife sheath. I mean, I think I included this and highlighted it just because it's odd that it's out of order. Like, why are you switching the timeline? Like, why is prior to it? It's just, anyway, okay. I think this is the end of it. It's just I just included this so we can just take another look. So what do you guys think? I did not see this, actually. Thank you for bringing that to my attention. That's interesting. If anyone wants to find that and post it in the Discord, we can cover it on another live stream. I'd be happy to. Okay, you're talking about Rex Human there. Okay. Yeah. So, I mean, the thing that stands out to me is the timeline of it all. And by the way, I didn't even read this part, but here again, we don't know, one, when the extraction was finished, and two, when the DNA was sent to the private lab. But what we can glean from this, given to us by the state, right, is what the order in which things happened. And then, funny too, if you look, where are all the dates? The only dates on here are the ones I included up at the top. But this includes literally no dates. And again, this is from the state's reply to the defendant's objection to the motion for a protective order, the IGG tree, as I call it. So the only dates are the dates that I added. So when I have, we don't know, there's actually more dates we don't know. I just included two of them, but like there's more dates, right? Like basically they don't give us dates. Like there's no dates. Like the affidavit doesn't have dates, for like with a few exceptions, right? When you listen to even the testimony we just listened to earlier, right? From Brett Payne and Mowery, Lawrence Mowery. Like, I don't know when, I don't know who, I don't know when, no dates, no people, no names. Like, and like I asked you guys too, right? Like, imagine if you heard that in a trial, like we will hear that in a trial. It's like, what? I'm curious too what Franks thinks of this, because she's involved in the IGG world, but it just, like this right here, I think is really interesting. Okay, so let us go back to the filings that we are covering here. Okay, hold on. Aha, okay, so this is again the reply to the defendant's objection to the state's motion for protective order. So hopefully, are you guys finding any of this helpful? Hopefully you guys are. I know there's a lot of different like things that people, I mean, again, because we have so little information, it's there's a lot of different theories and whatnot, right? But my goal was, again, just like, as you guys can see, taking just the information like from the state, right? And the testimony from the hearing, like, and what dates do we have from them, and putting it on a calendar and putting it in a timeline. Like, this is what they gave, like, this is what they gave us, so we can like scrutinize it, right? Because if you do that, even without delving into social media, or even without delving into whatever, right? Even if you just go from like literally the discovery from the state, like the only thing I included in any of that didn't come from the state is the Othram invoice. That's it. And that came from Kevin Fixler of the Idaho Statesman, right? Other than that, literally everything is from the documents in this case, or the hearings. And if you just take that, like that, in other words, that's giving them that's giving them every benefit of the doubt. That's giving them every chance to prove a timeline that makes sense. And if you do that, you get what we already looked at, which is there's massive holes and things that don't make any type of sense logically and chronologically, right? Like, it just, does that make, do you guys see what I'm saying? Like, hopefully that was helpful. So like, you don't even need, my point, I guess, is you don't even need to get that creative, right? You can just take like literally the factual, like, well, what's given to us and presented as facts, right, by the state, by law enforcement, and like, look at what we got, right? Okay. So now, defendant does not have a constitutional right to discover all aspects of the investigation. Defendant contends that a massive investigation came to focus on him and him alone, and asserts that he has the right to discover the investigation that led to him. The context of his claim, he is asserting a constitutional right to discover anything and everything related to the investigation. I don't think that's what they're saying, but okay. but his asserted right finds no support in the decisions of the Idaho Supreme Court. The court reasoned that the state has a constitutional duty to disclose to defendant this. This is okay. Look, the court reasoned that the state has a constitutional duty to disclose to defendant exculpatory evidence material to the preparation of his case. Why did I highlight this? This is about IgG. This is about IgG. So, in other words, if they submitted that S&P profile to one of those databases and they found a match, right? They wouldn't have exculpatory evidence. They would have inculpatory evidence. The state has a constitutional duty to disclose to defendant exculpatory evidence. They're saying, I mean, do you guys see what I mean? But further found that there is no constitutional requirement that the prosecutor make a complete and detailed accounting to the defense of all police investigatory work on a case. The court can use the process explained in the state's motion to verify the IgG information does not, again, right here, guys, the court can use, let me just read this again. The court can use the process explained in the state's motion to verify the IgG information does not contain exculpatory evidence. So, okay, then what is it, right? Inculpatory? Though a criminal defendant has a constitutional right to discovery, that right is not infinite and it does not encompass the IgG information. Due process requires all material exculpatory evidence. Again, they're really using this word a lot, right? Exculpatory. As the state explained in its motion, the IgG information is neither exculpatory nor material to guilt or punishment. The family tree built, they really want to use the family tree, built by the FBI, which they did in lickety-split time, merely pointed law enforcement to the defendant, and law enforcement followed that lead to develop the substantive evidence of guilt that was used for his arrest and that will be used at trial. Defendant theorizes the IgG process was like a lineup where the government was already aware of who they wanted to target. Defendant's rigged lineup analogy defies logic. The purpose of a rigged lineup would be to use the flawed identification as evidence of the accused's guilt or to influence the witness to testify a certain way at trial. But here the state has not used and has no plans to use the IgG information to prove defendant's guilt. And the IgG process could have no effect whatever on the STR analyses. Moreover, as the DOJ policy on IgG explains, the FBI can only use IgG. This is important. The FBI can only use IgG after the investigating agency has pursued reasonable investigative leads to solve the case and the perpetrator's identity remains unknown. Let's take one other quick look here, guys. According to the DNA tree provided by the state, they submitted the profile to likely Othram again before they searched CODIS. And if you look carefully at the level here, honestly, either at the same time or before the S&P profile was submitted to genealogical databases. And again, that only makes sense because we know on the 29th they had sent that invoice. But not only that, like, and I don't know that anybody's noticed this, but anyway, this blew my mind. This was this morning when I noticed this and I was like, what? But nonetheless, I mean, MPD, as we've seen, was not really doing this investigation, even from the words of their own detectives, right? Everything that we heard in those hearings, right? Who did this? FBI, some investigators, right? I mean, like literally they didn't do anything. They don't have any information, you know? Okay, let me go back to the document here. And again, I have to say, I think IgG is being used kind of loosely in a way here, right? Because like I would say that if you just submit, okay, if you have a DNA sample, right, an S&P profile, and you just submit it into a database and you receive a name, I wouldn't call that IgG, right? Because there's no investigative genetic genealogy happening. That happens when you build out a family tree. And as we know, that takes time. So I think that there's maybe, again, a bit of plausible deniability that because those databases were just used, right? Like if you just log into the portal, if you submit it on there, there's a plausible deniability potentially that, okay, it's involving IgG, it's in the realm of IgG, you know what I mean? And as we heard, right, there's a lot of loopholes and workarounds and whatnot that they can have to bypass things and to have shortcuts and to find out people who've opted out, that all that stuff, right? It would be exculpatory evidence if it could be someone else. Absolutely would. Yeah, I think that they've been really careful. Again, the plausible deniability is strong. Like, again, going back to the whole thing about the ghost, as I've been calling it, right? Like the fact that the question here, hold on, let me pull this back up. Did you guys ever submit any ideas to this question? This question here, why? Where it says search results on or before November 29th, as per Othram Invoice, local law enforcement then decided the FBI would take over. Why? Like, that's the question, right? Why? We know that they already have this contract, right? We saw the invoice. Why? Again, ostensibly Othram. Why would they have generated the S&P profile, submitted it into databases? And again, according to the state, right, they started building a family tree, and given no reason, why did it says local law enforcement decided FBI would take over? Why do you guys think that is? What do you think happened? Like, what do you guys think happened? What could have happened when Othram, or whatever, whoever, like, but ostensibly Othram, submitted the profile to the genealogical databases. They got whatever results they got. And then why after that do they say, okay, now the FBI is taking over? Why? Think about it, guys. I don't want to tell you what I think. I want you guys to see what you think. But this is kind of going back to like the whole thing about, the FBI is required to then delete the things, and then the FBI just doesn't save their work, and there's nothing we can do, and blah, blah, blah. And again, remember too, right, when you look at the timeline that we already went over earlier, that they already had them by the 16th, December 16th, right? How did that happen so quickly? Like, even if you try to say by any stretch of the imagination that the FBI they went to work, right, as it said in that dot, they went to work and they created a family tree and they did it lickety split overnight, and they did that and they worked really hard, and then they that's how they got to him, and they were able to do all that in like 2 weeks time. Okay, even if you go with that, that still doesn't answer the question. Even if you go with that, that's giving them every benefit of the doubt, although it strains credulity. That still doesn't explain why, after having already paid, right, money to Othram, after, in addition to the S&P profile, right, there's the extra $4,500, why they had Othram again ostensibly started building a family tree, quote unquote, but then, okay, no way, sorry, FBI is going to take over. So that answer to that question, I think, is really important and could give us some insight into what maybe happened here. Shady O, is Shady O a person, or are you saying it's shady? Okay, so I see so I'm gonna read this part. So I think they're saying, I think Denise is saying, I think they had his DNA from following him and match it to his buccal swab. I think you're on the right track, but here's the other thing, right? How did they get to following him in the first place, right? How did they get to following him? And remember, the first question we were talking about earlier too with the calendars was the 29th. Again, the years they were given was 2011 to 2013, but yet 30 minutes apart on the same day, two WSU officers, one of them queries white Elantras, sees a 2015 white Elantra, doesn't exclude it, and it says Bryan Kohberger. And then 30 minutes later, without talking to the first guy, you've got Officer Whitman driving around looking for white Elantras in the middle of the night, and then happens to see one. It's a 2015. Well, again, you should eliminate it, right? Why didn't you eliminate it, right? And looks up the plate, and it's registered to Bryan Kohberger. I forgot where I was going with that. Right. Okay. Yes. So that would point to there's some reason why they didn't eliminate that car, right? And remember, the Othram invoice came in on the 29th. I think that's significant. As an I. Thank you for clarifying. So, I mean, even if you take the car out of it, I mean, the reason we're even talking about the car again is because it's part of what has been said, I guess, by the state, right? As to how they got to him. Although, again, they kind of vacillated, like it's vague. Anyway, the white Elantra, right, it's like there has to be, if you're giving them every benefit of the doubt, there has to be some way that they got to him initially. And so looking at the timeline, it's just tough though, right? Because given the timeline from what this says, right, they had the white Elantra that they were looking for before they had, before local law enforcement received the tip, which was December 19th, right? Although again, we already know that FBI knew who he was. So again, you can take the car out of it. Even if you remove the car from the equation, like again, looking at this on the screen has nothing to do with the car at all, right? This is just the DNA. And I feel like a lot of this is important. And so, I had an extra arrow on here. I meant to delete. There's an extra arrow with no text. Anyway, so again, the question is like, how did they, how do they get onto him so quickly? If that makes sense. Oh, thank you for asking this. Thank you for mentioning this. So I forgot I had something else to show you guys. Hold on. So I had another thought too, as I was doing all this. This is again, I had laryngitis and I couldn't live stream, but I did a lot of research. I had another thought as I was thinking about the sister, right? So this is from this is the article, right, that we all heard about. Bryan Kohberger's sister searched his car for evidence, but this is talking about when he's cleaning his car, right? Okay. I haven't heard anyone ask this question. So I'm gonna ask this question here in a second. So Bryan Kohberger's sister feared that her brother was involved in stabbings. According to a bombshell report, sources told NBC's Dateline that one of the older siblings grew increasingly suspicious of her brother and his behavior during the holidays. Her suspicions were so great that at one point, several family members searched Bryan Kohberger's white Hyundai Elantra for possible evidence. Okay, so Franks, if you're still here, Franks was asking the question of when did he leave with his dad, right? It says here in mid-December. So remember, the only dates we would have would be coming from this body cam videos where they pull him over. But if anyone wants to look up the dates of those and let me know in the chat, because the reason she was asking is, again, we were doing the timeline, and the December 16th, they followed him to the CVS in Pennsylvania. But this says mid-December. Embarked on a cross-country trip with his father, right? But during this time at home, his family members noticed he was behaving somewhat bizarrely. I'm trying to get to the part. But the concerns were clearly big enough for several of the family members to reportedly decide to search the 28-year-old's vehicle to look for possible evidence. But here we go. By that point, police said Mr. Kohberger had already been spotted cleaning his car out with bleach. So the family members didn't find anything of note, the source said. So you guys remember when this came out, right? His family saw him cleaning the car, right? With bleach. So it dawned on me, and I hadn't heard anybody mention this, but it seems like I'm sure somebody has. But anyway, the thing that I thought was crazy was like, why would he be cleaning his car a month after the murders, right? If he's already at home, right? Mid-December. Like, not only is that over a month after the homicides, but it's also after your dad's been in your car and you rode cross. Like, I just dawned on me. I was like, wait, what? Like, cleaning. So the whole thing about him cleaning out his car with bleach, it's like, it doesn't, I guess it could be round two. I don't know. Do you guys see why I'm like, why that's like there's no report to my knowledge of anybody seeing him clean out his car in Washington after the homicides, right? This is the only one I know of is with, and I don't know everything, obviously, right? I don't pretend to, but that his sister or his family members saw him. So this is already mid-December at the earliest. So, I mean, that just is interesting to me. I mean, IAS is asking great questions. Is there evidence that was bleach? Nope. This is just what they said. Cleaning his car out with bleach. And the thing is like, it's even if it was a different cleaning product, it still would be weird if like you wait that long, right? Like, again, you've already had your dad in the car for a cross-country trip. Like, he's been pulled over by law enforcement along that drive. Like, it just, wouldn't you do it sooner rather than later? You know what I mean? They didn't find that. I don't know. Where do we know that from? Because again, that they didn't, because I feel like that would be something that would be kept until trial, right? The evidence from his car or what they find or don't find. I feel like I know there's been reports that they didn't find anything, but I don't know that we know that like for sure. I don't know. Right. I mean, that's why I'm bringing it up, is because I'm just saying it doesn't make any sense. Right. So, whether, to say that somebody's lying or not lying, I mean, I'm not going to accuse any, I'm just saying it doesn't make logical sense to wait that long for anyone to commit a crime if they get in a vehicle afterwards. Right. And then to wait that long before cleaning their car. Right. And yeah, I mean, I have a regular routine to clean my car. I clean my car regularly. My car is really pretty much clean. Like, I clean it regularly. So people are always like, how does your car so clean? I'm like, well, I clean it regularly. So, it's not like there's anything, it's not like cleaning your car is weird, like, to me, right? The thing that would be weird is if you commit a quadruple homicide, right? And then you also drive across the country with your dad, right? And then a month later, or at least a month later, then you decide to clean it. That's the thing that would be weird, right? So glad you're here, Heather. Happy you're here. So it says, though, okay, thank you for that suggestion. But what the what the document says from the state, right, is it says law enforcement obtained it on that day. That's what it says. Let me pull that back up. That's from this video. Hold on. Let me pull this back up. It's right after this. Because this is taken directly from, hold on, there it is. Observed, right? Kohberger, this is taken from the Google motion to suppress Google. Kohberger was observed entering a CVS in Pennsylvania on December 16th. And his email account and phone number was somehow obtained by law enforcement. So, you know, again, the observed entering, right? Right? But the thing is this, though, right? Because why, you know, the thing is this, right? Okay, the Pennsylvania thing, because he had just happened to get to Pennsylvania. Like, I could see if it was in Idaho, right, that they're looking for all Elantras in Idaho. And so, like, it's seen on a, like what we saw, right, from the clips we watched earlier, right, where it's seen on surveillance footage, blah, blah. But in order for, and I appreciate that you're thinking it through with brains. Thank you for this. To say like that in a trigger, the CCTV trigger. Okay, that's a really good thought. I'm just thinking again logically, because if that happened and it triggered something in Pennsylvania, that would mean that this was happening, would have been needing to happen nationwide, because they would not have had any reason to be looking into Pennsylvania more than anywhere else. In fact, they'd be looking into Idaho, right? Or maybe Washington, or, you know, nearby states. So, but it is a good thought. It is a good thought. I mean, a great point here from Neeson Z's. My question is, why would the state not be straightforward about the details of the case if they saw it? Absolutely. I mean, again, like I said earlier, guys, like asking yourselves that question. We were watching the clips from the hearings. Like, imagine hearing this at a trial. We would literally never hear this. It's absolutely absurd. And we can watch it again for any of you guys who weren't here. It's short. I've got, you know, there's some really interesting things we did earlier, but it's, you know, it's just, you would never, it's crazy. It's crazy. Right. Well, the other thing, it's not just that they don't know what their experts will say. It's like they're wanting to wait for the defense to say what their experts are going to say until they then say what their experts are going to say. That's the thing. Which is swapping it, right? They're swapping it. They're wanting to be the defense and let the defense be the state and go first. Right. Shout out to Flash, man. How did your Discord stream go, Flash? So and again, like, let me pull this back up. The thing that was so crazy too that we talked about was okay, hold on. Here. Right here. Par for the course. Most of the disclosures have catch-all phrases that the expert will rely on the work of unnamed others. Again, the ghosts, as I've been calling them tonight. The work of unnamed others. And then again, you look at what we watched earlier too with all the testimony from Brett Payne and Lawrence Mowery. it's ghosts. It's like ghosts did this case. Like, it's pretty insane. Okay, so let's keep reading from some of this too. So in any event, the state is not asking this court and Mr. Kohberger to assume anything. If the court finds that the IGG information is relevant to guilt or punishment, the state is simply asking for an opportunity to provide additional information to the court in camera. Again, to see if it's exculpatory. I mean, they keep using the word exculpatory. I mean, it's interesting that they use the word exculpatory so many times, as we pointed out, instead of like relevant, right? Because why would you use exculpatory unless you're trying to distinguish it from something else, right? By the way, if you guys, and for anyone who's new here, welcome. And I'm glad that y'all are here. We love having participation in the chat. Welcome. And please feel free to join the Scroll Crew in the Discord too. Nightbot will put a link for that in the chat. Oh, that's awesome. Candace and DSN came. That's great. I love it. That's awesome. I've been streaming. That's why I wasn't there. But yes, I'm glad to hear that. That's awesome. Right. They think it's up to the defense to put on a case first. Absolutely. And right. That's also true. Well, yeah, there's a crossing of state lines to commit murder. Right. But the thing is that the FBI does not ever automatically get involved in a case unless it's something like a civil rights. There's a very few exceptions, like, you know, where the FBI is going to, like, it's automatically going to be in their jurisdiction. Even when crossing state lines, the FBI only gets involved when they're asked to by local law enforcement. And as we know, they were asked and then kicked out, which we see a lot of times in these small town cases. Delphi would be another example. They bring them in the beginning to do certain things, and then they get rid of them so that then they can say that they cracked the case or whatever, right? It's their case, whatever. And I just want to point out too, a great example of doing it correctly for involving the FBI, Florida, when Florida gets something right, I try to say it right. So in the Casey Anthony trial, which I'm covering gavel to gavel right now too, they utilized the FBI all the way through, as in not just to be like getting around more stringent requirements for search warrants or whatever, right? They utilized them all the way through. They never kicked them out. A lot of the witnesses for the state, and actually for the defense, to that end, a lot of the law enforcement that testified in that case, I would say a lot, like over half probably, were FBI that worked on the case. So they did it correctly in terms of utilizing the FBI and keeping them involved because they actually wanted their help and not just like whatever, you know? So yeah. Which is funny too, because like they actually have more resources than some of these small towns do. So shout out. I see another new friend here, toes turning over every stone. Happy to see you. Awesome. Glad you're here. Glad all the new squirrel friends are here. Okay, so let's see here. Let me keep reading here. So the declaration submitted by a defendant do not make the IGG information discoverable. I mean, but also though, the reason this is interesting to me is because there isn't any information, right? It was all deleted. Isn't that the case though, state? In support of his third motion to compel seeking much of the IGG information at issue here, defendant submits 2 declarations. Neither of the declarations show that the IGG information falls within the scope of Rule 16 or the defendant's constitutional right to discovery. In fact, the court should disregard much of the contents of those declarations as irrelevant and beyond the scope of the issues before the court. So Becca Barlow. For example, Barlow's declaration states as fact that the IGG information in this case is clearly Brady material, and that the IGG search could yield a relevant admissible statistic. Setting aside the improper nature of Barlow's declaration, the declaration contains two primary assertions. Neither of the assertions support the defendant's attempt to discover the IGG information. First, Barlow suggests the IGG information in this case could give defendant additional investigative leads, because in some instances, the IGG process leads to a pool of individuals rather than one specific individual. She provides several examples of other cases where investigators supposedly had to contact individuals for further family information to narrow down the pool to a single individual. I was literally just thinking. So if anything, Barlow's theory supports the state's request for an in-camera hearing so the court can decide whether the IGG information contains exculpatory information. So remember, this was before the IGG hearing. And the thing is that I don't think that those witnesses that testified at the IGG hearing were provided anything specific to this case. And by that, I mean also because remember, the FBI doesn't have anything, right? They don't have anything to turn over. So, thinking about the witnesses at that hearing, I have to wonder, like thinking about that testimony, right? It was really more like not specific, right? It was more like, here's how it works, here's what can happen. And I think the most important witness, this is just in my opinion, was, and I'm blanking on her name right now, but the awesome lady with the hair and the shirt that were opposite colors, and the one who explained the back door and the loopholes and all that, right? And how all that stuff. That I think is, to me, and again, she was testifying to that. She doesn't need to know any of the facts of this case and didn't testify to anything specific to this case. This is just, how does this work? What can happen? Anyway, second, Barlow argues that the IG information could provide defendant with a database match probability statistic, which she states would be relevant and admissible. She supports this proposition with US v. Jenkins, a case that had nothing to do with IGG and that ironically demonstrates a fatal flaw in Barlow's declaration. The court should reject Barlow's attempt to hijack its role in determining the relevance and admissibility of evidence. Oh, interesting. Her own source of authority explains that the DMP answers the question, guys, what is the chance probability of obtaining a match by searching this particular database? As in a direct match? Oh my God, look at this. But the FBI does not search genealogical databases in the IGG process for the purpose of finding a match. That doesn't mean that if there's a match, they won't see it, though. Look at this. This is crazy. The FBI is looking for relatives of the contributor. Are you saying, hold on, Santa, are you saying that if they put an S&P profile into a database and they receive a direct match, as in the person whose DNA they have also submitted DNA, right, on one of those databases? Are you saying that if they get a direct match, they're going to ignore it and instead look for relatives? Is that what you're telling me? Look at the wording here matters, guys. And this is the question I had been asking myself in my head for a long time as someone who had submitted my DNA to MyHeritage to learn of like my ethnicity stuff. And I have always been thinking this, right? I've been thinking to myself that there's always so much talk about the family and the family tree and the distant relatives. And I kept thinking you've got enough people that submit their DNA on these things, right? That the more people that do it, like the odds that someone will either commit a crime or not commit a crime, but that their DNA might be considered a suspect, right? And that they will be a direct match to themselves. Like, it's bound to happen. Like, it's only a matter of time, right? Like, I've been thinking this for ever since I first submitted my DNA, which was a long time ago. I mean, probably 2 years ago. And I was like surprised that I hadn't heard of that happening yet. But that's funny because that's exactly what this question is. What is the chance or probability of obtaining a match by searching this particular database? A direct match, right? But the FBI does not search genealogical databases in the IgG process for the purpose of finding a match. This is the stupidest thing I've ever heard. Because are you trying to tell me that that would not be better? Wouldn't that be preferable? I don't care if that's not your purpose. This is insane. The FBI is looking for relatives. Okay, so you're going to ignore a direct match, and it's like, this is stupid. Of the contributor of the DNA found at the crime scene. I can't. Now here, Barlow says the comparisons in such a database do not yield. I wonder if this is taken out of context, because here it says she's basically contradicting herself, apparently. Again, that's why I'm wondering if it's taken out of context. Because also it doesn't make any sense. Like, literally, if I had my DNA from a separate thing and submitted it, I would get a match to myself. Because my DNA, like, you know what I mean? Like, it's just, this has got to be taken out of context here. And again, she's just asked this question here. But now there's a footnote. So Jenkins, oh, whatever, it's from earlier. Oh, wait, cold hit. Hold on. That a DMP statistic in an IG, I don't know what a DMP is, in an IgG case should be treated the same as a DMP statistic in a cold case hit with no explanation. Look at this. By simply asserting that she has spoken with a number of experts who say that it is so. At least in Idaho, we call that hearsay. Wow, sassy. And defensive, I would say, as well. Like, look at this. At least here in Idaho, we call that hearsay. I mean, a cold hit, that would be the direct match. That's what that would be. Where you put the DNA in and you get a match because the person submitted their DNA. Okay, Stephen B. Mercer. Stephen B. Mercer. All right, he's the dude that's like an attorney. Right. The thrust of Mercer's declaration is that the state should be required to disclose the IgG information because under the ABA standards, defense attorneys have the duty to investigate. But the standard he cites belies his claim. Were the mere assertion that a defense attorney has a duty to investigate sufficient to compel disclosure of the IgG information in this case, it would be sufficient to compel disclosure of anything and everything in the state's possession in every case. I mean, the thing is like, again, what this is saying is it can't be required. Like, my response in my brain was like, they should turn over everything, in my opinion, right? Like, in other words, whether it's inculpatory or exculpatory, because they keep citing, like, if it's not, we all know exculpatory has to be turned over, right? But I mean, shouldn't inculpatory evidence be turned over as well? Like, we're all, you know, and again, while that's not the requirement, it's still considered best practice. And again, take the example recently of Hank Brennan, right? Who, you know, gave the example, like, we're turning everything over, even if we don't know what it is, we're turning literally everything over. And every good prosecutor, you know, or former prosecutor that you hear talk about, you know, or, you know, attorneys that are, in my opinion, ethical and, you know, regardless of what type of law they practice. But again, even if you look at prosecutors, former prosecutors, you know, they always say, like, that's the best practice. Turn it all over, right? And you know, And this came up in Baldwin, right? This came up in Baldwin because remember, Carrie Morrissey said, as far as the information that was put in that separate file was given a different name or whatever, right? And she said, we determined that this wouldn't be of any use to the defense. She may have said we determined it wasn't exculpatory, but one or both, right? Either way, Judge Marlowe said, it is not up to you to decide what is or is not helpful for them. That's up to them to decide what would be helpful for them, right? And that's why it should have been turned over. It's not up to, like, it doesn't make, and that's the other thing, like, it doesn't make sense for the prosecutor to be the one to decide, would this help the defense or not help the defense? So is this relevant to them? Blah, blah. No, you turn it over. And that's the thing, right? So and again, I always give Florida credit where they earn it. One thing about Florida, right? We know that they have the open discovery, right? They are really big on that, that you just turn everything over. But again, it doesn't have to be Florida, right? It's, I haven't even been looking at the chat, but yeah, I'm so engrossed in these documents here, guys. Yeah, the Baldwin case. Yeah, thank you. Yes. So, yeah, you guys, I'm sure most of you guys, if not all of you guys, know what I'm talking about there. But that's a really good example because her deciding to declare a mistrial with prejudice, can't bring the charges again, all of that, right? All of those sanctions imposed upon the state. Her entire ruling was based on, it's not up to you being Carrie Morrissey, to determine what they could or could not find helpful. And she makes that exact point. It's like, because Carrie Morrissey tried to argue, well, this wouldn't have made any sense for them to use it, blah. And she tried to argue, and she says, nope, that is not, because you don't know, you can't get inside their minds. Like, it's not for you to determine what's the point. It's not for you to determine, it's for them to determine. And that, like, that right there, what that is that saying, right? You turn it over. Everything you have, you turn it over and let the defense decide what to do with it. So, I mean, right? Yeah, I mean, I've never seen personally any case where the prosecution is really fighting, like, is just like with everything, right? I mean, it would be one thing if they fight it one time, right, for a motion to compel, but then they like just to fight it, even though they shouldn't be fighting it at all, but then they're like, okay, fine, right? That'd be one thing, but like, think about, like, in other words, think about the effort, think about the energy it is taking for the state with every single filing to continually have to make a supporting argument and present case law and blah, blah, right? And to argue it on and on and on to fight turning things over. Think about how much more energy that would take and how much more time that would take than just turning it over, right? The vast majority of the filings in this case are related to the discovery not being turned over. Okay. Conclusion. Okay, let's see what else we got here. Is there anything? Oh, this is in California, so not binding authority for this court. Okay. So yeah, good job, Santa, not. So let me pull up here. So for anyone who didn't see it, let's just take another little look at this. So again, crazy to me that according to this, right, CODIS was after submitting to Othram. So yeah, and again, the other thing too, right? Like the whole thing about, let me just go forward. Like that they started to develop a family tree, and then the FBI took over, you know, and then there's like so many dates just missing, And oh, here's the part about them going, the FBI went to work building family trees. You guys, I'm picturing right now, because I guess my brain needs to find something silly, like in like Snow White and the Seven Dwarfs, and like, hi ho, it's off to work we go. And like, I'm just like, that's where my brain's going with this right now. Like off to work you go, you know, because like, this is just such a funny thing to even say. I mean, literally, that's why the first thing that comes to mind is like the dwarfs in that little song. Anyway. Yeah, I mean, and by the way, Flash too, because I know that you know, I had referenced to you earlier about clarifying the timeline. We watched the video earlier, but it'll be timestamped, but there's a good video here with the calendars for a timeline here. And for anyone who missed it too, that'll all be timestamped. Cake on the brain cake, not ice cream today, huh? So yeah, I don't think I have anything else. Last I checked, the witness list still was not up yet. So I will continue to be on the lookout for that, as I always say. But yeah, let me just make sure. Let me see if there was any other filing here that I had pulled up, because I always have a million tabs. We did. No, I think we got everything. I mean, again, this the catch-all phrases, right? Like this, right? Like, how do you even say this, right? In this, as the state, like that, if you're the state, that you include something here, right? In the materials, right? The disclosure does not in any way limit the scope of the expert's testimony. I don't know how you even have the guts to say that, right? When we all know what a Richardson hearing is. We all know that you cannot testify beyond what you include in your disclosure, which should include an opinion, although they didn't hear. But you literally, state or defense, cannot do that. Again, in the Casey Anthony trial that I'm covering right now, like, we saw both sides get sanctioned left and right over and over again. There's been, like, the previous episode was called Defense Expert Drama for a reason, like, and it's ongoing. The fighting is insane. But it's just sanctions left and right. And it's all pertaining to expert witnesses. All of it is pertaining to expert witnesses. And sorry, I can be more specific. All of it is pertaining to expert witnesses attempting to testify at the day in trial that they're testifying, right, to a new opinion, or even not a new opinion, but maybe even a more expanded opinion, or literally anything that wasn't in their report. Or that, like, sanctions, like, on both sides have been happening. It's not allowed. So actually have a cake. Well, then go have some cake. So, so guys, I think that's it for this live stream, but, I do appreciate all of you guys for being here. And for any of you guys that are new, welcome to the Squirrel Crew. Happy you're here. You know, on my channel, for anyone who's interested, I do have a playlist for every case that I have covered and I'm currently covering. There's a lot of them. Right now I'm covering a lot. You know, tomorrow I believe we're doing, what are we doing tomorrow? Tomorrow we're doing the Adelsons. And then I think the next day we're doing, I can't remember. We got Karen Reed coming up. We got Casey Anthony coming up. We got Shanna Gardner coming up. Adelsons, all kinds of stuff. But love to see you guys in the chat again as well. And again, feel free to join the Discord if you haven't already, if you're interested. But yeah, but that's it for this one. Hopefully some of this helped. You know, I did my best. Again, part of what we can see from the calendars is just how many dates are missing, right? So, you know, that's equally as important because that's unusual, right? Like that's equally as odd. Like the dates that are there are odd, and also the fact that there's so much missing is odd. So, but that's it for this one, guys. But love all of y'all. And Flash is going to go eat some cake. Awesome. And again, if anyone has that, the latest in the Rex Heuermann case, please feel free to, the only way to really send a link to something would be through the Discord. But I would be happy to cover that. And I may be able to find it. I'll take a look and see if I can find it too. So thank you so much. Thanks for being here. Thanks for all of your input, everybody. Love y'all, and see you guys next time.